Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
This court hearing quickly turns intense as a self-described sovereign citizen attempts to challenge the judge's authority and push the limits of courtroom decorum. From the very beginning, the tension is noticeable, and it becomes clear that this approach is not going to work in his favor. As the exchange unfolds, the outcome becomes increasingly predictable, and it does not go the way he expects. For those unfamiliar with sovereign citizen arguments, they are based on belief that an individual can choose not to follow laws by declaring themselves outside government authority. While these claims may sound convincing to those who believe in them, courts across the country have consistently rejected them. Judges are well aware of these tactics, and they do not alter how the law is applied. What makes this hearing stand out is how quickly the situation escalates. Each attempt to challenge the court only tightens the judge's response, turning what might have been a straightforward proceeding into a cautionary example of how not to behave in court. The back and forth is intense, surprising, and at times difficult to look away from. This is one of those courtroom moments that keeps you fully engaged from start to finish. Share your thoughts in the comments. Do you think the defendant realized too late that this strategy wouldn't work? And if you enjoy courtroom breakdowns like this one, don't forget to like and subscribe for more daily content.
Hello, Tariq Samar, Tariq Day here.
Already Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Here's an important detail that immediately stands out. Despite claiming he would arrive at 3:30, the defendant actually shows up right at 3 o'clock. That timing alone undercuts his earlier statements and quietly confirms something he's been trying to deny the entire time. He clearly recognizes that the court has authority over him. If he truly believed otherwise, he wouldn't be following the court schedule so precisely. This moment doesn't go unnoticed by the judge. In fact, it sets the stage for what comes next. The court is about to address the issue directly, because providing inaccurate information or misleading the court altogether is taken very seriously in the legal system. Honesty is not optional in a courtroom, and even small misrepresentations can carry real consequences that, in legal terms, misleading the court can rise to the level of contempt, which is a serious matter. Contempt isn't just about disrespect. It's about actions that interfere with the court's ability to function properly. When someone wastes the court's time or plays games of the process, judges are well within their authority to respond firmly at this point. The defendant is learning a hard lesson. Court is not a place for tactics, delays, or half-truths. Every word matters. Every action is noted. An attempt to manipulate the situation usually backfire instead of helping his case. This approach is putting him in a more difficult position. What do you think about this strategy? Do you believe he thought this would work, or was it a miscalculation from the start? Share your thoughts in the comments. This moment alone says a lot about how these arguments tend to unravel in real courtrooms.
Sir, you indicated that you wish to represent yourself on this matter.
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding, third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
It's honestly difficult to follow the logic behind this defendant's approach. First, he gives inaccurate information to the court about his arrival time. Then he enters the courtroom ignoring basic procedures, immediately challenges the judge's authority, and demands that the entire case be dismissed. His main argument is that the court has no jurisdiction and that the case shouldn't exist because, in his view, there is no injured party. But that reasoning falls apart almost immediately. Jurisdiction isn't optional, and it isn't something a defendant can simply reject. The moment you appear in a courtroom, especially after being summoned, the court clearly has authority over proceedings. Judges deal with these claims regularly, and the law is very clear on this point, AS, for the argument about there being no injured party. That's another misunderstanding of how the legal system works. Not every case requires a specific victim to be present. Certain charges, especially those involving public safety or failure to comply with lawful orders, are prosecuted by the state itself. In cases involving fleeing or eluding, the issue is a violation of the law, not whether someone was physically harmed. Right now, the defendant seems to be treating the hearing like a debate rather than a legal proceeding. He's repeating talking points that may sound convincing to him, but they don't align with how courts actually function. So far, this strategy isn't helping his case at all. It's only highlighting how unprepared he is for the reality of the courtroom.
Finish?
Oh no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
Is anyone else starting to feel a bit conflicted watching this unfold? At this point, the defendant is being firmly corrected at nearly every turn, and Judge Simpson's patience with sovereign citizen arguments is clearly wearing thin. You can tell she has encountered these claims many times before, and she's no longer entertaining explanations that don't align with established law. The defendant appears to be treating this like an early, informal discussion rather than a serious court proceeding. Unfortunately for him, this is not a practice round or a preliminary debate. It's a real hearing with real consequences. The gap between his understanding of the process and the reality of the situation becomes more obvious with every statement he makes. What's particularly difficult to watch is how confidently he insists on points that simply don't apply here. He seems to believe he needs to present evidence or argue legal theory at this stage, without realizing that the court is addressing procedural and jurisdictional matters that don't work the way he thinks they do. His arguments may sound logical to him, but they don't fit within the legal framework the judge is required to follow. This is exactly why legal representation exists, and why courts often encourage defendants to seek counsel. Free or low-cost legal aid is available in many situations, specifically to help people avoid mistakes like this. Instead of accepting that help, he's attempting to out-argue the court itself, a strategy that rarely, if ever, ends well. Judge Simpson's responses make it clear that she's focused on efficiency, clarity, and keeping proceedings grounded in reality. And while it may be uncomfortable to watch, it serves as a strong reminder that court is not a place for improvised legal theories. Understanding the system, or having someone who does, is essential, especially when the stakes are this high.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer there was
You
a
stood mute. You stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demure and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
Don't need to-
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion.
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it, because I can deal with it right now. What's the personal jurisdiction?
Do you think this defendant truly misunderstands the process, or is he intentionally confusing the issue? At this point, he's asking the court for a jurisdiction hearing, but it's clear he doesn't fully grasp what that actually means. A jurisdiction hearing is meant to determine whether a court has the legal authority to hear a case at all, and that question is typically raised at the very beginning of proceedings, not well into an active case. If someone genuinely believes a court lacks authority over them, that argument must be made before the case moves forward. Once a defendant appears in court, responds to the summons, and participates in the process, jurisdiction is generally already established. In this situation, the case is scheduled, the defendant is present, and the court is clearly exercising its authority. What makes this moment stand out is how firmly established the court's jurisdiction already is. The defendant arrived on time, entered the courtroom, and engaged with the judge, actions that directly contradict his claim that the court has no authority over him. Jurisdiction isn't something that can be dismissed mid-hearing with a simple request or phrase heard elsewhere. IT raises an important question. Does he truly want clarification on jurisdiction, or is he repeating legal language he's heard without understanding how it applies? Courts rely on procedure and precedent, not improvised arguments. At this stage, the hearing isn't going away, and the process will continue as scheduled. What's your take on this moment? Do you think he believes this request will change the outcome, or is it simply another misunderstanding of how court proceedings work? Let me know your thoughts in the comments, and let's jump back into the hearing to see how the judge responds.
As well as the state lacks personal jurisdiction, I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing, because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you, and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today. And
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
in person.
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
just for the record, I'll put it on the record that I object. But under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
Well, I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paper.
You can check out at the front desk.
Okay.
At this point, it's clear the defendant is relying on sovereign citizen arguments, but the bigger question is how Judge Simpson handled the situation. Some viewers might feel the judge was firm, or even blunt, but was that actually too harsh? Looking at the circumstances, it's hard to say the response was unfair. The defendant entered the courtroom treating the hearing like a negotiation or a game, and Judge Simpson responded by bringing the conversation firmly back to reality. Rather than allowing the hearing to spiral into endless legal theories, the judge set clear boundaries and made it known that the court would not operate on made-up rules or internet-based interpretations of the law. That approach may have felt strict, but it was effective in many ways. It sent a message that courtroom proceedings require preparation, respect, and an understanding of how the legal system truly works. There's also a larger issue on display here. Sovereign citizen beliefs have been spreading more widely, often fueled by online forums, conspiracy theories, and misleading legal advice. These ideas encourage people to believe they can avoid responsibility by rejecting authority altogether. Unfortunately, when those beliefs collide with real courtrooms, the outcome is almost always the same, and rarely in the defendant's favor. What we're really seeing is a pattern of individuals attempting to bypass accountability instead of addressing the charges directly or seeking proper legal guidance. That's why judges like Simpson choose to shut these arguments down quickly. Allowing them to continue unchecked doesn't help the defendant, the court, or the public. Some might argue that stronger enforcement and clearer consequences could reduce the number of people bringing these claims into court. When hearings are disrupted or delayed by arguments that have no legal standing, it costs time, resources, and public money. Maintaining order and respect in the courtroom isn't just about authority. It's about keeping the justice system functioning properly. Now I want to hear from you. Do you think Judge Simpson handled this case appropriately, or did the response go too far? Was this a necessary reality check? Or could it have been handled differently? Share your thoughts in the comments. I always enjoy reading your perspectives.